So, welcome to Probate Weekly Podcast, where we often interview probate attorneys or probate litigation attorneys that litigate, or trust administration attorneys, or we've interviewed title company account executives or underwriters. Never had the pleasure or the need to talk to a title company litigator, but I heard her on a recent podcast. Shout out to Sam Price, one of the best podcasts on probate. Courtney Ryder is the litigation attorney and vice president at Fidelity National Title. Courtney, thank you for joining us today.
Of course, no problem, Bill. Happy to be on, and definitely a shout out to Sam Price. Also, if you get a chance, also listen to his podcast, Probate Notes. It's a great series. So.
Must listen. He gets it. I just poach his guests. I've got all kinds of content thanks to him. He's fantastic. So Courtney, most of us, I'm a real estate agent. Most of the people on the call are. We get a lot of attorneys as well. Most of us think of title reps as the person who gets you the title report, preliminary report, maybe research information, deeds and comps and stuff like that. In the old days, you used to bring us pens, pads, cookies, occasional sponsor items. But you actually do work for the title company. You actually protect the title company's interest or the customer's interest. Talk a bit about what is a litigation attorney inside a major national player like Fidelity National Title.
Absolutely, happy to, Bill. So basically, what my job entails is I work on the litigation side of for the title company, and basically what that means is essentially, obviously, when you buy a property, and you're purchasing title insurance, and pretty much anyone in California that buys a property gets a title insurance policy, and if they don't, they should. And so essentially. What that does is that protects you and makes sure that you have good title to the property. And what that means is that when you go to sell or refinance a property, there's no issues. And the title company, when you buy the property, they're able to insure that and provide you with an insurance policy. So on my end, what I do is I help handle the litigation side in the event that there are any problems that require litigation to resolve. And how that works is you purchase a title insurance policy, and let's say you want to sell your property later on down the line, and you discover that there's an issue with title, and this happens more often than not. There could be issues such as simple as the legal description is wrong on your deed, or bigger. There could be bigger issues such as, issues that with there was an outstanding interest that never was dealt with. So the issues are wide ranging, and so you make a claim with your title insurance policy, and then the claim eventually goes through a claim center in Omaha. They make what's called a coverage determination, meaning they confirm that this type of issue is covered under the policy, you're covered. And then if it does require litigation, it gets routed to one of our team. And we call it IHL, which is in-house litigation. And so we're nationwide. We have offices all throughout the nation because, as you mentioned, Bill, Fidelity is one of the major players. We have Chicago title insurance, lawyers, Commonwealth. So pretty much the one of the big players in the title industry. And again, if any of the claims involve litigation, it will get routed to one of our offices, and one of an attorney like me, and we attempt to kind of analyze, handle it, and represent our insured to resolve the issue. So that's kind of just generally how it works.
So again, there's a lot that goes on behind the scenes at a title company, and one of the things behind the scenes also in your case, because you work for one of the largest, if not the largest, I think one of the largest for sure, is that you have multiple brands that really kind of roll up. So when somebody gets a title policy from Chicago Title, it's part of the Fidelity National family of companies or whatever you want to call it. And so number one, people should know that. And oftentimes there's smaller companies that Fidelity has a relationship with, and really you're kind of getting the brand of the small company. Maybe it's an escrow company or a broker that has it, but it's really Fidelity that's behind that, and you want to have those resources behind you. Now, it's interesting, as a real estate agent, I would say, okay, true confessions, I've not been a big fan of operations of companies like yours, that title insurance is about insuring reasonable risk. Like you have a house and it's there's trees and there's fire hazards, but you take reasonable risks, you get it insured. I feel like title companies sometimes only insure a policy once there's three belts and four sets of suspenders, and then everything is in a glass enclosed. The fact that you even have any work at all as a trial litigator on matters regarding title is news to me, because it seems to me, no offense, whenever there's been a claim, the title company just says no and makes you kind of go through the whole process of getting sued. So talk about what are the more, not that we want to encourage claims that are unfair or unreasonable to your company, but what are the more common types of claims that you have to litigate and defend the policy, or defend, in this case, the buyer of the policy, but most commonly a buyer?
So,
I think we lost your audio. I'm sorry.
issues with the description, and most people that I see, because I'm also a certified specialist in probate and estate
Hold on 1 second.
planning.
I think we've lost your audio. Did you do something to your microphone?
Oh,
It sounds
is this better?
much better.
Okay, sorry about that.
That's okay.
So going back to a couple of examples that I could provide. Some common examples are, like I said, issues with the legal description on vesting deeds. Those are kind of the more simple ones that if we get cooperation, we can kind of correct that fairly easy. Others are outstanding interest. Let's say a kind of a common one is people think that a property is held in joint tenancy, which has attached to it a right of survivorship. And just to explain that a little bit, basically, if a property is held in joint tenancy, it has what's called a right of survivorship, which means it goes to the other joint tenant rather than pass through, let's say, intestate succession or kind of through any other means, through the natural heirs of a person. And so sometimes kind of another common issue, what I see a lot is people think that the property is held in joint tenancy and it's really not, or there was something that happened prior in the chain of title that inadvertently severed the joint tenancy, and no one realized it. And so there's this outstanding interest that needs to be resolved. That's a fairly common one. And like I said, since I am a certified specialist in probate and estate planning as well, I do see a lot. My practice and kind of what gets assigned to me are what they call dead people cases involving either outstanding probate matters, 850 petitions, which are basically quiet title actions in the probate world. Right. And a lot of kind of common things just generally in the title litigation world is some certain neighbor disputes. If there are lot line trees, certain boundary disputes, things like that, I've dealt with. A lot of easement issues, either interpretation of certain easements, things like that. So it's a wide variety. But I feel like the most common, usually what it stems down to, and kind of what we do is what it stems down to is actual title to the property. Whether we have good title or disputes related and relating to that.
Yeah, typically you're buying a house from a stranger. How do you know they own it?
And
how do you know, even if they own it, how do you know how they own it and what rights they have to distribute it? And I think sometimes people take it for granted, the process, and it's just paperwork, and they blame the bureaucracy. The reality is it does provide important service. It allows us to transact with strangers or out of country and such. So I imagine there are cases that you look at and go, what a knucklehead. Why didn't they just do this? Why didn't they fill out this piece of paper ahead of time to protect themselves rather than subject themselves? So what are one or two examples of easily preventable things that people could do that end up not being done and as a result create work for you or litigation for your company?
Yeah, sure. A couple of things that, and this is more like I said on the information side of things. Since 2020.
I'm sorry, I need to get you a little closer to the microphone again. I'm sorry.
Sorry. I'd say it's all of 2020. As far as kind of looking back and seeing what should have been done. I mean, unfortunately, by the time that we get it, usually the mistake or inadvertent mistake kind of has already happened. But some things that you can kind of do to prevent it is obviously, I would say, just go through if you're a either first time home buyer or something like that, just make sure you do, first of all, get a title insurance policy. Just that's kind of
Right.
just a point of fact. Another thing is also be in communication with your title insurance company as you go through the process. There are certain things that you do need additional endorsements for. Like I said, sometimes you need to buy as you're going through the process additional coverage. I think certain things such as boundary disputes, you do potentially need to purchase an additional endorsement and get a survey just to confirm the boundary lines at the outset. So some things like that that can be done in the on the front end. Additionally, also when you're signing the closing docs, I mean, I get this all the time. Make sure you take a look at it. I mean, obviously I get it. It's a bunch of paper, right? When you're sitting down at a closing, but I mean, make sure a couple of things like your name's right on the deed, the legal description, the assessor's parcel number, little things like that can potentially, you know, kind of alleviate issues down the line. Definitely. Another thing is obviously it's okay to communicate with your title company and about something that doesn't necessarily pass the smell test, so to speak. Like if there's an issue with chain of title and you get the preliminary title report and you say, okay, this deed was, signed 2 years after or 2 years before it was recorded, why is there something that takes so long? You know what I'm saying? And so like little things like that, you can do to kind of prevent issues down the line, I would say.
I had a case where we had a probate, and out of the blue, somebody lodged an objection with a will purported by the decedent, and it turned out the will was dated, or no, not, I'm sorry, a grant deed signed by the decedent, purportedly, well, out of the country, and the date of the deed was 2 years after he died. So this
Like
fraud
that
artist,
doesn't pass the smell test, sure.
right? It was interesting that I had title companies who would not insure it, and I had to change it to a third, second, and then a third title company to say, look, here's the death cert, here's the grant deed, the signatures. We got a low priced, non, probably standard person to verify the signature because it was obvious it wasn't a signature, and also the date. And yet the title company said, we need the court to verify that, and the court wasn't going to do anything. They're not in the business of invalidating deeds. They just have a will. So we actually had to get different title companies. So these are things where sometimes working ahead of time, you can avoid that. Now I guess the worst would have been had we sold the property. They could have come back later and made a claim, and now you have a problem. And so the whole key is to get these things done in advance. I have to say that most of the good account executives at your companies, at your family companies, are open to getting a prelim when we file probate, because let's get the work done while we can ahead of time. I'm sorry, you get. We're having.
We want to kind of address things at the very beginning and make sure.
Hold on, something's happening to the audio again where it just seems to have disappeared. Do you hear me okay?
Yes, I can hear you.
I mean, I hear the words you're saying, but somehow it's very faint. And then if you just step back an inch, it seems like it disappears entirely. Let's see. I hate to do this.
Better?
Yes.
Okay, I apologize. My audio was off before.
There you go. You guys on Zoom, and here we're on StreamYard. I understand that. I do that all day long.
Right. Okay. So this should be better now.
Much better.
And so we take a lot of pride in our prelims and just making sure that things are, quote unquote, tight and right at the very beginning. And part of that is making sure if there are issues with title, that we get things like, for example, a probate order, or make sure all that stuff is recorded in the chain of title to make sure things are on the up and up.
Yeah.
Granted, I mean, there are things that you can't stop. There are various nefarious people that end up, forging signatures, like the example that you just gave, things of that nature, which isn't obviously we have to deal with those kind of subsequently. Those come out of the woodwork. But at the end of the day, and to be honest, there is only so much a title insurance company can do.
Right.
Right. If something looks good on its face and there's a presumption that it's a notarized document, it was duly recorded, obviously we're entitled to rely on that. And then, if, and that's why in truth, I have a job. If subsequently there are issues arising from that, or issues with title that need to be resolved, invariably that gets routed to, someone like me, to help resolve. So,
Seems to me that, and I've been in business now for about 40 years. Obviously, our population is getting older. The percentage of property owned by older people is getting older. I think different forms of dementia and Alzheimer's are becoming we're more aware of it. I presume it's more common, but also for sure we're all more aware of it. But in real estate transactions, I see much more common fraud, attempted fraud, and so to me it seems some of the solutions are worse than some of the problems. I see people promoting title lock, which I don't think really provides any real benefit from these types of things. I just encourage family members to check the title on your family property, every 30 days. It doesn't cost anything to check. And if nothing's being done, you're probably okay. What types of frauds do you see happening, or litigation cases, I guess, arising from fraud do you see happening? And what are one or two things you might suggest to family members or friends to protect themselves?
absolutely. So, some things that I see that are fairly common, especially kind of in this probate world, and you kind of hit on it as well in just your previous statement, is a lot of forgery. And what most people don't realize is that, and these are issues that we end up having to deal with. Let's say there was a forgery, and it conveyed title, or there was, obviously, again, we're the title insurance company. We can only do so much. We relied on this, didn't know, on its face, it didn't look like a forgery. And then subsequently, obviously, we insure even a subsequent owner who wasn't even a party to that deed. And then
Right.
there's an outlying claim, as well. There's an outlying claim, and most people don't realize this, that obviously we're a subsequent purchaser. There's the benefit of having what's called bona fide purchaser status. If you paid full value of the property without any previous knowledge of the claim, then you actually can argue that you have superior title. Ultimately, it would be up for probably a court to decide, but that's under the law, that's a pretty good affirmative defense. Now, most people don't realize that if there was a forgery, a prior forgery, what happens is that bona fide purchaser argument is unavailable, and
Mm.
the deed is void rather than voidable. So some things that you can kind of do to, I guess, prevent that, just kind of for family members and friends, is you made a good suggestion. Just occasionally check title to the property. Make sure nothing's been recorded. You can go down to the county recorder's office. There's a lot of online services that you can use that I think some are even free, that you can kind of pull deeds to the property and
From
things
your
like that.
friendly Fidelity National Title Rep, for example, there's an app you guys give us that we can check
Yep,
title and get copies of deeds. I use
absolutely.
that every day. Yes.
Yep, absolutely. So that's also communication with your family members directly if they're elderly, or in, let's say, some type of assisted living or something like that. Regular contact and communication, because, like you said, undue influence kind of is very prevalent, and sometimes that goes in hand with the forgery issue. If you have kind of one specific family member kind of that is influencing an elderly person, or potentially taking advantage of this elderly person, helpful to check in with them again, and make sure, and another huge kind of thing to help protect
oneself from things like this, such as, fraud, forgery, things of that nature, is proper estate planning. That's a huge thing that you could definitely do. And I am a huge advocate of proper estate planning, because what that does is most people think estate planning just avoids probate, which in and of itself is a huge benefit, right? The time and the cost you save from doing an estate plan is just a benefit in itself rather than go through probate. And most people don't realize that probate fees are actually set by statute. And most people don't realize that the fees are actually set by the California Probate Code, and they're set by the value of the estate. So the attorney's going to get paid what they're going to get paid by assisting you with this probate, and that's just written in the statute. And an estate plan comparably is a lot cheaper, and you get to kind of have that kind of peace of mind as to not going through a lengthy court process. The other benefit of an estate plan is you get to plan for your incapacity and things that happen if you, let's say, do get diagnosed with a cognitive disorder such as dementia, Alzheimer's, things like that. You have something in place that designates your wishes when you're not able to speak them. Right. And that's also a huge benefit to estate plan and to having an estate plan. And what that does is that helps kind of cut down on these title issues, right? You have everything set and things like that. So those are some things that you can kind of do to prevent, any type of forgery or fraud related to title to your property.
And also, I think, provides some additional defense against fraud. I've seen a case where the decedent had this whole, or not decedent, I guess in this case it was a conservative, had this whole estate plan done because he wanted the estate distributed a certain way. Then you had this kind of wild deed to his caregiver / new girlfriend / quasi wife, and that gave everything to her. And they tried to argue it was a forgery or he was incapacitated. But one of the proofs was, well, when he was of sound mind, he had this whole elaborate plan, and that was witnessed, and everybody knew about it. And in the dark of the night, this deed shows up, and so the court has to work through there's other legal issues, but at least one piece of evidence supporting that this looked bad was he had an estate plan. He had paid money to do it, involved numerous family members, and the fact that he would do a deed and just cut everybody out seemed unlikely. Again, there's a legal process of that to go through, but it just was one more piece of evidence. And it's just amazing how outlandish some of these attempts are. I mean, I see this occasionally. This must be your world. You must see this all the time. And you need to talk to this person who, they ripped off the person, and they're in court trying to defend themselves as being the victim, of course, right?
Yep, absolutely. There are certain cases that I've had where it's clear that, again, the deed or the conveyance doesn't necessarily pass the smell test, but right. At the end of the day, there's a person kind of defending it to the hilt. And ultimately, like you said, it does need to go through, for those type of cases, we kind of know it's going to go through the court process and we're going to have to litigate this thing. But it's also unfortunate to see when especially elder people are taken advantage of, and right. It's unfortunate to see, and unfortunately that does happen more more often than people would want to realize. Yeah. And so again, I feel like the courts do a pretty good job of sussing that out and are able to kind of parse these issues out. Another thing that a lot of cases don't necessarily go to trial, even with title issues, and so ultimately there's some type of resolution to the litigation if we need to file some type of legal action or defend some type of legal action. Invariably settlement is always explored at some juncture during the litigation. And the benefit to that as well is kind of both parties kind of know the result and there's an actual kind of resolution. And you don't necessarily let the court decide, and it could go either way. Usually in court, there's a winner and a loser. Whereas if you reach a settlement, maybe both parties are able to reach some type of agreement that they can live with, right? And I always joke that a good settlement is one where both parties aren't happy, like they
Correct.
feel like they left something on the table. But if cases like certain cases get litigated, it's ultimately up to usually a judge, and most people don't realize that that especially if you're in the probate world dealing with title issues, which invariably come up, and kind of what my focus is there's no jury in probate. There's no entitlement to a jury, so it's ultimately up to the bench officer to decide these issues of fact.
Right.
And invariably, like I said, there's a winner and a loser.
I think the other thing that your clients or the general public doesn't understand is judges today, particularly in LA County, have huge caseloads. At least you can argue whether it's true or not, but what's not in doubt is they feel incredible pressure to move the caseloads and towards resolution, as many as possible. And they feel, and again, that you can argue it, but certainly they almost every single time I'm ever in court, the judge will say how busy they are, how full their caseload is, and how overwhelmed they are. And so you have to be sensitive to that to realize the judge wants it resolved. I mean, you feel like you're in a train going downhill. He just wants this thing done, or she, regardless, male or female. They just want it done. And it's almost like if you have legitimate cause for litigation, you're somewhat at a disadvantage because it's tough to prove enough, let alone you have a judge who really wants this disposed. And yet, sometimes you can't get the other party to agree. So talk a little bit about how do you, and I do with customers who are in the same situation, right? There's objections and there's, other parties who are trying to sue for different things. And, the judge seems so rushed, so hurried, and the customer, wants, and there's times to be heard and times not to be, meaning it's not, even not in the hearing stage, but in the daily calendar, people want to plead their case, and the judge is like, look, I'm just going through the procedures right now. That's not the right time. We'll deal with it. So talk a little bit, how do you balance between, getting attention for your client, and I guess in your case, mostly the company, and at the same time, not upsetting the judge and meeting their needs for efficiency?
Absolutely. And I think the biggest thing, to your point, absolutely, I totally agree that judges have hugely impacted calendars, in any county. And so in a hearing, you could be one of maybe 35 to 40 on the calendar, right? Like the judge is hearing in their morning calendar. So what I like to practice in order is to be efficient and efficiently move the case along is be as prepared as possible for the hearing. Obviously, I've kind of understood the procedure. I've been practicing for over 10 years now. And so specifically in probate for going on 6 to 7. So I've kind of seen different things in probate. So I pretty much am able to anticipate, depending on what it's on calendar for, what's either going to happen and things like that, and try to be prepared as possible. So that's one point that I can say for any either client or attorney that's listening to this, be prepared as possible. Additionally, like you said, there are certain junctures where you are able to offer argument or argument evidence to support your position. And typically the process is you go through these hearings. If you're objecting to a petition, you file your written objections first. You do discovery. Again, that's just a way of being prepared, exchanging information. And then invariably the court sets what's called an evidentiary hearing. And what that does is that's essentially in probate, essentially the trial. That's where the judge hears the evidence. So obviously the judge in any other hearing isn't really going to hear any type of argument. They may say, hey, what's going on with discovery, or talk to you about a specific issue at the hearing. But the time where you really want to present your argument is obviously at this evidentiary hearing. And typically, if a matter is being contested in probate, the court will eventually set an evidentiary hearing. But there are certain benchmarks that you need to do to kind of get to that point. Like I said, obviously, file written objections. Most people don't realize this. You can actually go to a probate hearing and orally object to something, and that is allowable procedurally. But what the court will then do, likely when you show up initially, and I've had to do this just because we've just gotten into the case and haven't really gotten a chance to, formulate our written objections, show up, object to the hearing, and then what the court will likely do is set a deadline for you to file your written objections. And so again, just preparing those, being as prepared as possible. And then that just alerts the court that this is a contested matter that likely needs to be set for an evidentiary hearing. Then you do your discovery, and in probate, discovery follows the same model as a regular civil case. You can do, the regular forms of discovery, written discovery, depositions, exchange experts if you need to. A lot of things that come up, going back to the forgery issue, obviously people, both parties would likely need to get a handwriting analysis or from a handwriting expert. So you do some expert discovery, and all that takes place to help you prepare. And then the court will invariably set, like I said, an evidentiary hearing. And that's your opportunity to call your witnesses, present your evidence. And like you said, the court is really impacted. So luckily, that's not going to happen really anytime soon, like right when you file the case. But eventually, you will get your day in court if it goes that route. It does take a long process, but to your point, Bill, usually a lot doesn't happen at these procedural hearings. The court kind of just checks in and sets certain control dates where things need to be done, certain deadlines, and you follow those and you follow the process.
I'm in a case now that there's objection lurking, and they told on the prior hearing, they told the judge in court they're going to object. They didn't make the objection. They didn't announce it. They just in passing discussed the objection. And so my client said, well, when do they have to file? And I said, well, I'm not an attorney, but the code says up until the hearing, they can object to this particular petition. They could walk in the door and just verbally object. The problem is that the court hates that, because you have plenty of time to file your objections, then you'd have a date, then you would just file for continuance to that date. The judge doesn't have to see you till you show up, and they're happy. But if you show up and then you object, what he wants to ask, or she wants to ask the question, why didn't you just do it ahead of time? Why do you make us reschedule here in public with all these people? There's 50 people waiting. And so I think there's the legal side and there's the business side. And I think you really hit on the head, which is be prepared, follow the rules, know the rules, anticipate the judge. And I just feel like there's some very great attorneys who know the law. They went to great law schools. They win all kinds of other cases. But probate court, man, you better know those procedures, because it seems different. Mm-hmm. One of the questions I want to ask you, I know you're based in LA. What percentage of your work is LA County versus what percentage of your work is other counties?
So I work in the LA office of, like I said, Fidelity's IHL team. And so we actually handle basically a large part of Southern California. So any type of thing. But I would say most of my cases are based in probably one of three counties, primarily being LA County. I do practice a lot in San Bernardino, Riverside as well. I would say those are probably my kind of three main counties. I do have certain cases up in Ventura County, some in Santa Barbara. So those things. And then we do actually have an Irvine office that handles primarily San Diego and Orange County cases. But I do have a couple of those sprinkled in as well. But I would say my three biggest counties that I practice in would be LA, San Bernardino, and Riverside. And yeah, go ahead.
And the other counties, because they often include items from LA County, or is it just that your workload covers as well San Bernardino only matters and Riverside only matters? Or is it only because LA might have a property in San Bernardino or might have a property in Riverside?
Yeah, it's a combination of things. Like, some of them are kind of one-offs in, like I said, Kern County, Ventura County, things like that. So it just depends on where the claim is, I feel like. And then also, our manager obviously assigns the caseload. So if he attempts to be, my manager attempts to be geographically cognizant of kind of where certain offices they're easier to get to and things like that. So it does depend.
Seems to me that the business of probate court law is so different in each county. It's almost a completely different experience. Orange County, I go there occasionally on a sale. The judge greets everybody. Hey, how you guys doing? Nice to see you all. I go on to training classes in probate real estate, and they'll say, oh yeah, go up and meet the court, clerk and say hi to them and maybe offer to bring them out to lunch. I'm like, I'm in LA County, man. There's bulletproof glass. You don't talk to anybody. You don't get near the judge. Maybe talk to the bailiff ahead of time and say, good morning. Otherwise, just sit in your chair and stay out of trouble. It's just so different from county to county. It seems to me that if I was hiring an attorney on a matter, I'd really want to make sure that I knew that they were being in the primary county. I understand why, in your case, you have multiple counties and it's a business that has to support these other areas. But I would think my advice to people is, if you're going to hire an attorney, make sure that's the county they know, not just the state law, the local rules, and probably the personalities, who the other trial bar members are and who the judges are or the bench officers. Is that for advice?
Absolutely. That is great advice, Bill. And then just piggybacking on that great advice is a lot of times, if you are looking for an attorney to represent you in a probate or regular civil matter relating to title to your property, a good thing to do, rather than kind of just a random Google search and things like that, is reach out to the local bar association. So if you're in San Bernardino County, reach out to the San Bernardino County Bar Association. A lot of them do have attorney referral services that are either free or charge just a very nominal fee. And by nominal, I mean maybe between 40 to 50 bucks. And they can provide you with attorney referrals, and you can meet with them. And most attorneys do give in private practice. Like I said, I'm in-house litigation, so I don't really take outside work. But just if you are looking for an attorney to represent you in either a probate matter or civil matter related to title to your property that's not covered under a title insurance policy, definitely looking at the local bar associations, because it is a great kind of first step, because of the fact that these attorneys that are active in the bar association, and I am active in LA County, San Bernardino County, and Riverside County bar associations, attend continuing education classes at these county events. These attorneys are active in the county, and again, probably like you said, know kind of the scope of the judge's even temperament, the judges, certain judges' temperament, or at least how the process is, and they always say probate is a very small world. So I do know a lot of people that practice in probate in, like I said, San Bernardino, LA, and Riverside counties, and it's a small world, and so you want to get that type of representation that that just gives you a little bit of an edge, I feel like. Absolutely.
Yeah, I know the bar also has a specialization, and so they'll usually refer you somebody who has that specialization in trust and probate.
Absolutely, and there is. So again, I am a certified specialist by the state of California Bar in probate, trust, and estate planning, and so is Sam Price, who we talked about earlier. He's also
He's beyond a specialist.
Yeah. And then, so what you could do as well is the state bar website, actually, where all the attorney roles are listed, does have that designation. You could actually specifically look up certified specialists in the respective counties as well.
And also, if it'll show on the calbar.org website if they have any pending or previous enforcement actions.
Previous disciplines.
Interesting.
And things like that.
I had somebody who was threatening me with a lawsuit, and they got the letter from the attorney, and I looked up online. The guy was himself under criminal prosecution for something. He's like, wow, that's your attorney. That's impressive. And the thing that I always tell customers why it's important to get the right attorney is, because I'm in the marketing side, I pull all the cases that are filed in LA County. 90% of filings are probate filings are by attorneys who've done one case in the last 12 months or less, meaning it's either their first case and only one, or maybe it's their second. Versus you talk to, there's some attorneys who are doing cases all the time. Now, no, litigation is different, right? Because typically you didn't file the case, maybe you're coming in midstream, not you, but I'm saying the litigation attorneys. And so again, you want a specialist who knows the other attorneys and who knows the judges and knows the rules. So again, I find that to be the biggest mistake people make is they have an attorney help them with a DUI or their business and corporation. That's not the right attorney for probate, and certainly not right for probate litigation. You want a cold stone killer if you're going to be litigating, I think. So
Yeah, exactly. Or someone that zealously advocates for you and is assertive. Again, it's always good to look up any attorney that either you're referred to or something to the state bar. That's a great resource. Just verify, first of all, that they're even licensed, right? Like that's
their license is active, how long they've been licensed. When I see a license issued before 1980, it's like, okay, you probably have a problem here because this guy's been around a long time, or gal. And so
exactly.
Yeah.
And
I would say, anyone that called local LA County, also feel free to reach out to me. I'd be more glad to interview. I've seen a lot of great attorneys, a lot of bad ones, and I'll send you the right one. Courtney, she seems really nice on the phone now, but she's a litigation attorney. That tells you that in court, the horns pop up, the fangs come out. She's got big steel claws. She's very pleasant on the phone to us, but I assure you, you can't have that job and not be really tough.
Right, absolutely, and tough and prepared, assertive, and there's been, litigation is inherently contentious, right? Like absolutely. So you're the other side that you're kind of dealing with obviously has a completely opposite position than you. So obviously there's a modicum of civility that you have to kind of adhere to, but at the end of the day, you represent your client, right? At the end of the day, and you want an attorney, like you said, that can zealously advocate and again protect your interests, which is you want that attorney, especially if you're involved in litigation, in a contested matter. Absolutely.
Well, Courtney, I know we've kept you a little longer than I'd originally planned on. I just want to thank you so much for taking time to educate us and to help us understand the business as it goes overall. If you want to get more information from Courtney, she is at Fidelity National Title. And again, they have a whole umbrella of companies. I happen to use regularly Lawyers Title Insurance Company, Kevin Sales. They're one of the Fidelity National companies. So their policies are rendered by them, and Courtney supports them litigation-wise. So again, you want to work with a company that has all those resources. Courtney, thank you so much for joining us today. Thank you so much for sharing with us the information and helping us be more effective in our business.
Absolutely, Bill. Such a pleasure.
And for the rest of you, this is Probate Weekly. We get together every week, usually with a probate attorney that you might use for probate or probate administration litigation. In this case, I think it was great to kind of see the other side litigation from the title company side, who's meant to protect us as real estate transactions, realtors and or buyers and sellers. We do this new episode every week. If I can help in any way, reach out to @BillGrossProbate. Put your comments in, like, share, subscribe if you like this. As always, make today your best day ever. Thanks so much.